Hello, and welcome to UK Employment Law, the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights recent case law and legal developments of importance to UK employers. It is presented by members of Mayor Brown's employment team and occasionally features special guest speakers who are involved in changes in employment law. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions. We hope you enjoy the podcast.
Hello and welcome to the Mayor Brown Employment Podcast. I hope everyone's well. We have two very different cases for you on this episode. First, a case about TUPE and whether an employee can have their employment contract split and transferred to two different employers. And secondly, the first case so far about disciplinary action taken by an employer against an employee for refusing to wear a face mask. Once again, I'm delighted to be joined by my partner in the employment team, Miriam Bruce, who's going to talk about the face masks case. But before that, we have TUPE and what is an extremely significant decision. This is the case of McTear and Amey versus Amey, which was a decision of the EAT at the end of February. As I say, it's all about whether an employee's employment contract can be split so that it transfers to two or possibly more employers on a TUPE transfer where there is more than one transferee. Until now, and for many years, the position under the UK law has been that this is not possible and that an employee can only transfer to a single transferee. So where you have an employee working across different parts of a business or service, you have to work out which part of the business or service they are predominantly assigned to, if any, and that is where they will transfer. However, in March last year, we had the decision, which we've talked about before, from the European Court of Justice, which said that it is possible, under the Acquired Rights Directive, for an employee to transfer to two or more different transferees in proportion to the work that they do on each part of the business or service that's transferring. And that was the case of ISS Facility Services versus Govertz. Now, when the Govertz decision came out, everyone agreed it was hugely significant, and we've been waiting nearly a year to see the extent to which it would be followed in the UK tribunals. And now we have the answer, because it has been followed in the McTear case. So, the facts in McTear were as follows. The case related to an outsourcing contract between North Lanarkshire Council and Amey Services. Under that contract, Amey undertook the replacement of kitchens within the council's social housing. So the council would issue an order to Amey identifying the properties where kitchens were to be replaced, and Amey would carry out the necessary works. In order to carry out the work most efficiently, Amey created two teams of tradespeople, plumbers, electricians, plasterers, etc., to fit the kitchens. Now, both teams were capable of working independently of one another, and both teams covered the whole of the North Lanarkshire area. Now, in 2017, the council retendered the contract and they split the work into two geographic areas, one covering the north of the region and one covering the south. Those contracts were retendered and ultimately awarded to Amey, who was awarded the northern contract, and McTear, who was awarded the southern contract. Now, Amey's position was that this amounted to a TUPE transfer, specifically in this case a service provision change TUPE transfer. And so Amey worked out which employees were to go to which of the new contractors. Now, to do this, they looked at each of the two teams that had been established for the work, and they analysed which geographical areas each team had worked in during the last 12 months. And by doing that, they concluded broadly that one team had predominantly worked in the north, and so they should go to Amey, and one had predominantly worked in the south, and they should go to McTear. Now, McTear and McTear disagreed that this was the correct approach, and it seems they only took on a selection of the employees involved. And so we ended up with tribunal proceedings related to the others. The case came before the tribunal in February last year, and essentially the tribunal agreed with Amey's approach. Applying the domestic UK law at that time, they said that the employees who worked in each of the teams that Amey had put together transferred respectively to McTear and McTear. Now, the following month after the tribunal decision, the ECJ decision in Govertz came out. And so by the time the case came before the EAT, the question had become whether the Govertz decision made a difference to the outcome. Now, the first issue was the fact that the Govertz decision related to the ARD, and so it only related to traditional business transfers under the UK TUPE law. It didn't relate to the concept of service provision change, which is specific to TUPE. But unsurprisingly, the EAT said they couldn't see any reason why the Govertz decision should not equally apply to service provision change transfers as it does to business transfers. And so, having come to that conclusion, they said the tribunal's decision could not stand because the question of assignment of the employees had to be reconsidered in light of the Govertz decision. As a result of the Govertz case, the EAT said there was no reason why any of the Amey employees could not transfer partly to McTear and partly to McTear, based on the geographic split of the work that they had carried out at Amey. And so the case has been sent back to the tribunal to be reconsidered on that basis. And it's undoubtedly a hugely significant case, confirming that the Govertz decision and approach is being applied by the UK tribunals, assuming, of course, that it's not overturned on appeal. And as most of the commentators said at the time of the Govertz decision, it leaves some very difficult practical questions open as regards how in practice an employee's employment contract can be split between two different employers when a TUPE transfer takes place. For example, what are the terms that they transfer on to their respective new employers? Who decides what those terms are going to be under what are presumably two new part-time employment contracts? In terms of things like working time, geographical base, pay and incentives. And secondly, what if the employee doesn't want to become a part-time employee for two or more new employers? In the Govertz case, the ECJ said that if the splitting of the employment contract would adversely affect the rights of the employee, then the transferee employers will be responsible for any consequential termination of the employment contract, even where it's the employee who brings the contract to an end. And it seems to me that if McTear and McTear end up inheriting a large number of the Amey employees on a part-time basis, with them each working on each other's contract the other part of their time, and bearing in mind these are two competitor companies, they may not want that situation to continue. And like Amey, they may want a dedicated team of people to carry out the work on their specific contract. And so they may look to dismiss the employees and rely on those dismissals being fair on the ground that they are for an ETO, an economic, technical or organisational reason, which is, as we know, a fair reason to dismiss under TUPE. And then they may look to recruit a full-time employee or set of employees instead, which can hardly be the desired outcome under a TUPE transfer, where the purpose, of course, is to protect the employee's employment. Now, I'm sure we've not heard the last of this issue, and it will be interesting to see how it develops in the UK tribunals going forwards. But for now, that's the case of McTear and McTear versus Amey. And now I'll hand over to Miriam to talk about the case of Kubilius and Kent Foods. Miriam, over to you.
Thanks, Chris, and hi everyone. The case I'm talking about today has hit the headlines as it's the first COVID face mask case to make it to a tribunal hearing. It looks at the question of whether it's fair for an employer to dismiss an employee who refused to wear a face mask when asked to do so at a customer site. And this is the case of Kubilius and Kent Foods. And as our collective thoughts turn to consideration of a possible return to the workplace later this year, issues such as face masks at work will once again come to the fore. And whilst this case doesn't say anything new legally, it reminds us all of the principles which a tribunal might apply. So let's look at the facts of this one. Here the claimant was a lorry driver who would take deliveries to customer sites. On arrival at a particular customer site last year at the height of the pandemic, he was given a health and safety information sheet and a face mask. Now, he wore the mask outside of his lorry, but when parked up waiting for his goods to be unloaded, he took off his mask in his cab and sat with the window open. Now, on 2 separate occasions, staff at the customer site asked him to put his mask back on in the cab, and each time he refused. His explanation for refusing to wear the mask in his cab was that it wasn't set out on the health and safety information sheet he'd been given, and secondly, his cab was his place of work, and the government hadn't mandated the wearing of face masks at work. The customer remained unimpressed by this explanation, and he was subsequently banned from the site. Now, his employer had a policy that customer relationships were of key importance to the business, and in the handbook, staff were required to be courteous at all times and towards customers and comply with health and safety requirements of a customer when on site, including any instruction from customers regarding PPE. When told of the ban, the employer decided to treat Mr. Kubilius' refusal to comply as a misconduct matter. It carried out an investigation, including talking to the customer, but following that investigation, in which the customer had refused to rescind the site ban, the employer decided to dismiss Mr. Kubilius as it believed he had acted contrary to the express provisions in the handbook. In addition, the dismissing manager felt 2 factors were highly relevant to the decision to dismiss. First of all, the claimant had shown no remorse in the disciplinary hearing, and so they couldn't trust him not to take a similar approach in future. And secondly, there was no other suitable job for him to do. And that was particularly relevant given the customer in this case had refused to rescind the site ban. So the tribunal rejected Mr. Kubilius' subsequent unfair dismissal claim. Whilst they said that another employer might have issued a warning, the tribunal's view here was that the dismissal was within the band of reasonable responses. The tribunal felt that a reasonable investigation had been carried out. There was reasonable grounds to conclude that the misconduct had taken place, and therefore the dismissal was within the band of reasonable responses. Now, what does this case say? Well, despite the headline-grabbing aspects of it, I don't think it sets a precedent about face masks at work. It is nonetheless a good example of how misconduct dismissals relating to COVID-19 health and safety procedures might be approached by a tribunal, even if the outcome here does feel somewhat harsh, given the non-mandatory nature of face masks in the claimant's workplace. What is clear, I think, is that if the circumstances are right, an employer will be able to treat an employee's failure to follow health and safety instructions as a misconduct issue. And that appears to be the case even where the health and safety instruction being mandated is not a legal obligation, as was the case here with the face mask. However, to be successful in showing a management instruction related to health and safety matters is reasonable, communication of the health and safety policy by the employer to staff will need to be absolutely clear. In addition, the instruction must be reasonable in all the circumstances, taking into account individual factors when assessing whether a refusal to follow the instruction is justified. Here, the claimant's insistence that he could not be forced to wear a mask ran counter to the expressly stated obligations on him in the employer's handbook, and that was ultimately his downfall. I think the decision here would have been different had there been a protected characteristic at play, for example. If a disability perhaps was the reason he didn't want to wear his mask or couldn't wear his mask. I also think the decision on unfair dismissal would have been different had he shown some remorse in the disciplinary or had the customer rescinded the site ban. But given the outcome of this case, even though it's only a tribunal decision, some employers may look at it as providing comfort when faced with instances of staff refusing to comply with health and safety requirements on the grounds they're not compelled to do so legally. You can see that being particularly relevant for employers when considering the hot topics of testing and vaccination in the workplace and whether to mandate those issues. This case suggests that such an instruction might well be reasonable, although of course we shouldn't set too much store by that. The reasonableness of a management instruction, whether relating to testing, vaccination, face masks or any other health and safety matter, will always be highly fact-specific, requiring employers to balance many and varied considerations specific to its workplace and its workforce in demonstrating its approach is a reasonable one. So that's the case of Kubilius and Kemp Foods. I'm now going to hand back to Chris to bring today's podcast to a close.
Thanks, Miriam. And a very interesting case, as you say, particularly so given the increasing number of people who are likely to start to return to work during the remainder of this year, or so we hope. So that's the end of this episode of the podcast. I hope you found it useful. And as always, if you have any questions or comments, please do feel free to contact us. Until next time, stay safe and I'll speak to you soon. Thanks very much.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions, or want to know how to claim continuing education credits, please email Christopher Fisher, Head of Mayor Brown's London Employment Team, at cfisher@mayorbrown.com. Thank you for listening to the podcast.